Good afternoon and welcome to today's CCG webinar, Current Compliance Q&A, the State of Drug Testing Laws. I'm Jessica Polk and I'll be conducting today's presentation. And so we'd like to recognize today's presenters, Bill Current, who's the founder and president of the Current Consulting Group, and Yvette Farnsworth-Baker, who is a legal consultant with CCG. And so with that, we're going to go ahead and turn the time over to Bill and to Yvette.
Well, thank you very much, Jessica, and welcome everyone who's on today's call. I'm really excited about today's webinar presentation. I love presenting with Yvette. She just has a wealth of knowledge on state drug testing laws, and we're going to get to that here in a second. I just want to say as a precursor that this is intended to be what you want us to talk about. So we solicited questions ahead of time from the invitees, and we got a lot of questions to cover. Some of them are somewhat basic, and I'm looking at the people who are on the call so far, and we've got I know some very experienced state law people on the webinar, but we'll cover some really basic things so that we're covering everybody's questions. We'll get into some more complex stuff and also talk about the current state of state drug testing legislation, particularly marijuana, because a lot of you submitted questions on marijuana, what's going on with that. And so we'll touch on all of that. The agenda will kind of follow this format: some state law basics, the state drug testing laws, and the pandemic and how it's affected legislation and compliance with state laws. If you have some federal drug testing questions as well, we're happy to cover those. We didn't include them in the questions. We got some, we didn't put them in, but we're happy to take those as well if you want to talk about the new notice of proposed rulemaking for hair testing, or oral fluid testing from the October 2019 final regulations on that, or the current state of DOT, anything of that nature, we're happy to cover. We're going to try to get through as much as we can. This is really scheduled to be a 30-minute webinar, but we'll stay on as long as you have questions. So, Yvette, are you ready?
I'm ready. Thanks for that great introduction, Bill.
You're welcome. So let's get started. Let me get past these things. Okay. So, are there any these were questions that have been submitted that we went over ahead of time. Are there any state laws that prohibit workplace drug testing? Drug testing is legal in every state. There are no states that prohibit drug testing. There are lots of state laws that have conditions that are required for workplace drug testing, but drug testing is legal in all 50 states. Anything to add to that, Yvette?
Nope, just like you said, it's legal in all states. It's just a question of how you do it that differs state to state.
Okay. Now, what about a company that operates in multiple states? Maybe they're headquartered in Georgia or Florida or whatever, but they're in 20 or 30 different states. When they do their drug testing policy, how do they address that?
This is a great question. It's one that I get a lot, and sometimes I think people have a misperception. Some people think that it depends on where your company is headquartered, where your corporate is. For some laws that might apply, but for state drug testing laws, you need to drug test your employees based on where they are working, what state they are working in. So if you have employees in Georgia, the employees in Georgia need to be drug tested according to Georgia state law. If you have additional employees in Texas, the employees in Texas have to be drug tested according to Texas law, and so on and so forth. It has to do with where the employee is working and where they're being drug tested. Those are the state laws that you need to follow. I'm just going to add another question, because another question that's similar that I've gotten is, what if you have an employee who lives in one state but works in a different state? Maybe they live, close to state lines and they go back and forth for work. They need to be drug tested based on where they are working. So if you have an employee who lives in Alabama but works in Tennessee, because they live close to the border, just for example, if they're working in Tennessee, they need to be drug tested according to Tennessee's state law. It has to do with where they are working.
Okay, and that happens a lot, obviously. So
I'm going to put the next question to you then. How can a company address all the state laws that apply if they have employees in many different states? How can they put together a policy that addresses all these different state laws?
That is a great question, and it comes up a lot. And so I'm going to play off of your answer somewhat. One of the questions we get asked a lot is, do we have, because we write policies, and I know some of you on the webinar today write policies also as part of your business, but we get asked a lot if we have a model policy or a template, kind of a one size fits all, and we really don't. We don't sell model policies. That's not our business. We customize every policy, and so through TPAs, for example, that are resellers of CCG services, what we offer is customized policies that are based on what the client wants and needs in their policy. So it's based on their drug testing objectives, but heavily based on the state laws that apply to them. So for example, if they're in Georgia and they're not applying for the workers' comp premium discount in Georgia, it's a straight non-DOT policy, but they're in several other states, we'll base the policy sort of on as many common areas as possible from all these different states, so that the base policy includes as much as possible. It's an easy to use, easy to read document. But where there are differences, we will provide separate state addenda to cover those different state laws. So for example, Florida is a very easy state drug testing law state, but maybe this company also has operations in California, very complicated state. No actual state drug testing law in California, but tons and tons of case law. And so we'll create a separate addendum just for California or any other states that differ from the sort of the main things that are in their drug testing policy. So, but if you're in 50 states, it doesn't mean that you're going to have, 49 addendums to your policy. You're just going to have addendums for the states where there are differences, basically. Maybe you're in a state that you're doing lab-based oral fluid testing, but you also have operations in Maine or Vermont or Hawaii, the 3 states that don't allow lab-based oral fluid testing. And so in those states, you're going to have an addendum that talks about a different drug testing method used in those states. And I should clarify also, while we're on this, Yvette, that with these new lab-based oral fluid testing guidelines that came out from SAMHSA back in October, seems like forever ago, right? They only apply to federal workplaces, but I think had the pandemic not hit us, you would have seen a lot more companies sort of using them as sort of a blueprint for non-DOT, non-government type of drug testing programs. And we probably are seeing that to some extent because lab-based oral fluid testing has gone up. But the answer to your question is that we would write a base policy and then add individual state addendums to address any particular requirements in a state. So, and that brings up a good question. As I mentioned, Georgia and Florida, those are states with mandatory voluntary drug testing laws. And another state like Maine or Vermont that have mandatory drug testing laws. So Yvette, in sort of the world of workplace drug testing, what's the difference between a mandatory law and a voluntary law?
So a mandatory law, all employers who want to implement workplace drug testing, they all have to follow the mandatory law. That's an absolute requirement in that state. A voluntary law usually offers some kind of insurance discount, or there's some kind of benefit to complying with the voluntary law. But, as it says, it's voluntary. An employer, if they want to craft their own drug testing policy that doesn't fit the voluntary law, they're not going to get the benefits associated with the voluntary law, but they're not required to follow those guidelines if they want to craft their own law. So mandatory, all workplaces, all workplace drug testing policies have to follow the mandatory law. A voluntary law, you only follow those guidelines if you want to receive the benefit associated with the law.
And so there are some states that have different laws all at one time. We'll talk about some of those coming up in a second, like workers' comp and unemployment comp laws that affect drug testing. But there are also some states like Illinois, for example, which has a a law that requires drug testing of employers that have public works contracts with the state or grants with the state to do public works projects. And so those companies have to drug test according to that law that applies specifically to those types of companies, those types of state contracts, whereas the rest of the state wouldn't have those same restrictions. So it's sometimes not a matter of, you know, what does this drug testing law say, but are there other laws that can affect workplace drug testing? For example, the next question on our list is, you know, what about states with workers' comp laws that allow an employer to move to deny workers' comp benefits based on a positive drug test result? So I bet there are several of those types of states, right? And how do those laws work, and how do they affect drug testing?
Right. So actually, most states do have some kind of provision in their workers' comp law that would allow an employer. So say an employee has an accident on site or a workplace accident. You have a workplace drug testing law that provides for post-accident drug testing. So say someone has an accident, you do a post-accident drug test of that individual and they test positive for an illegal substance. Most laws will allow you to deny workers' compensation based on the positive drug test, but there's varying degrees of detail in those different laws. Some are just very, very vague, and then some are more detailed. An example is New Mexico is one state that has a very detailed workers' comp law. So if you have an employee have an accident, test positive for an illegal substance in a post-accident drug test, and you want to deny them workers' comp based on that positive test, you need to really make sure that your testing has complied with New Mexico's workers' comp law. And also in New Mexico, there's a very detailed system where the percentage of the compensation that's deducted is based on the degree to which the alcohol or drugs contributed to the accident. So just the states can have very different methods for denying workers' comp based on a positive drug screen, even though most states do allow that to some degree or another.
Does that also apply to unemployment compensation in some states?
Yes, and unemployment compensation, similarly, most states do allow you to deny unemployment compensation if someone is terminated based on violating your workplace drug testing. Again, it can be very vague or it can be very detailed. New York is a state that just has a very vague standard. If you terminate someone based on misconduct, then you can deny them unemployment compensation, but it doesn't go to any detail about what kind of drug screen or violation of the policy would be misconduct. It just leaves that vague. On the other hand, in contrast, Idaho has very strict requirements for how you have to conduct a test of an individual in order to deny them unemployment compensation. Idaho is a state that does not have a mandatory drug testing law. So you might have an employer craft their own drug testing policy. However, they terminate someone based on that policy. If that policy does not line up with the unemployment compensation requirements, then they can't deny that person unemployment compensation after terminating them because of the details in the unemployment compensation law. So there's just so many laws that come into play when we're talking about workplace drug testing. You know, you might think you just look at the workplace drug testing law in the state and that's that, but there's an interplay of many different laws. So workers' compensation laws, unemployment compensation laws, you definitely want to know what those are in the states in which you operate if you want to be able to, you know, deny compensation for people who test positive in a workplace drug screen.
Okay, perfect. So we've got mandatory drug testing laws, we've got voluntary drug testing laws, we have laws that are not really drug testing specific, but touch drug testing, like workers' comp denial laws, unemployment comp denial laws, plus the voluntary laws that offer worker or discounts on a workers' comp premium discount, or maybe some limited exposure to liability based on, you know, taking action on a drug test. The last question in this section of our webinar today has to do with pre-employment drug testing, and I'll just lead off on this one. because I've noticed that there's confusion about pre-employment drug testing's legality. And the truth of the matter is pre-employment drug testing is allowed, it's permitted, it's legal in all 50 states. Now, the confusion comes from the fact that there have been some states that have legalized marijuana, and as part of their legal marijuana law, they've placed some restrictions or conditions, maybe is a better way to put it, on pre-employment testing for THC and what you can do if a job applicant tests positive for THC. The most restrictive of all of these laws by far is New York City, which prohibits pre-employment testing for THC, except a long list of what the city refers to as safety sensitive occupations. So you've got a jurisdiction, the city of New York, that's created this very restrictive city ordinance when it comes to pre-employment drug testing for marijuana only. But even in that city, as well as some of the states that have kind of done similar things, there's still the acknowledgement that, you know, people under the influence of marijuana can be unsafe in the workplace. And so they've carved out these safety sensitive positions and occupations and allow employers who are hiring people to fill those safety sensitive occupations to continue to test for marijuana. Now, as well, pre-employment testing for all these other drugs that are typically mentioned in a state law, or maybe the state law defers to the SAMHSA guidelines, or I've even, you know, some of these state laws have antiquated language, so you'll see a reference to the NIDA 5, for example. We don't use that term anymore. But testing for those other substances, you know, amphetamines, cocaine, opiates, etc., or maybe even the expanded panels, is still allowed under pre-employment testing. Now, I'll just share with you anecdotally some information that was given to me by a client, DISA. You know, they're obviously a very well-known third-party administrator, and also, you know, a reseller of some of our services. And they have seen a dramatic increase in opioid positives and amphetamine positives in their random testing for their clients since the beginning of the pandemic. So when you look at these statistics that show that drug overdoses, for example, and deaths from drug overdoses since the beginning of the pandemic have just skyrocketed, well, these people aren't overdosing on marijuana, obviously. They're overdosing on opioids and other drugs. And so that becomes a factor when you're talking to a client about, you know, their drug testing program and whether or not they can legally conduct pre-employment drug testing. The answer to that is yes, in all 50 states for all these other drugs, and in almost every other state for marijuana as well, although there may be some conditions that apply there. So important to know that, because pre-employment testing, I think, is probably more important now than it ever has been, because we're seeing such a significant increase in substance abuse during the pandemic. And now as the unemployment rate's starting to come down, we're seeing a lot of people who've been using drugs during the pandemic at maybe increased levels now starting to apply for work again. And I think pre-employment testing has to be part of the equation. So again, folks, please submit your questions. We're willing and happy to take any additional questions you have. We'll continue sort of down this road that we have from the pre-webinar questions that we had. And we'll turn now to state drug testing laws during the pandemic or as part of the pandemic. So Yvette, I'll throw this first question to you. How has the pandemic affected drug testing legislation this year in the states? Are there still laws being passed?
There are still laws being passed. You know, there definitely was a slowdown in new legislation in March and April, but once we hit May, June, July, it started to pick up again, and there are still new laws being introduced in all the states, new laws being passed, and so it's definitely something we need to continue to keep our eye on, because legislatures are up and running and continuing to pass legislation.
And so what type of new laws have we seen so far this year? I mean, that have been passed in 2020. I mean, are there some that impact the workplace drug testing?
Yeah, absolutely. I think we're going to talk more about marijuana in the next slide, so I'm going to hold off on those because there's always a lot going on with marijuana. But I can give you some other ones that affect workplace drug testing. In Alabama passed a law that made it a crime to distribute urine additives or synthetic urine for the purpose of defrauding a drug test. So that's pretty interesting when it comes to urine tests and urine test cheating. That's a crime in Alabama now. New York passed a law, this is New York State, that requires pre-employment testing for drugs and alcohol of all drivers of for-hire vehicles transporting more than 10 people. So that's a requirement for pre-employment drug testing of certain employees in the state of New York. Oklahoma began or passed legislation to begin a marijuana breathalyzer pilot program. So that's very interesting if you follow marijuana law and this kind of new technology of marijuana breathalyzers. Oklahoma is starting a pilot program looking at that. Hawaii and Michigan decriminalized and are regulating hemp. That's not really related to workplace drug testing, but again, if you're following marijuana law, it's just interesting to note. So that's just a couple of laws that have been passed so far this year. There's still a few months to go in 2020. I think there's still going to be a lot of laws passed related to workplace drug testing in the next few months.
Okay, perfect. And I'll take a first stab at this next question. Have any state drug testing laws been suspended? I'm not aware of any. Are you, Yvette?
No, I don't think there have been any state drug testing laws that have been suspended.
So folks, your clients need to still be complying with the state laws that apply to them. And if there's a specific requirement in a particular state to do X, Y, or Z, they would still be required to comply with that. Now, it's a good question because I have been asked that question in other webinars, and I did have one person start out their question by saying, I know that random drug testing has been suspended in my state. What about, and he or she went on to ask some other question, but the truth of the matter is random testing had not been suspended in that state. And so there is some misinformation out there. It could be the result of, some just sort of bad press or something, but state drug testing laws have not been suspended. You're still required to comply with the state laws that apply to you. And that would be true in, virtually every state. So, but if somebody on the line today is aware of something like that, please put it in the chat section and we'll mention it. Because our time is short, let's move on to marijuana. Yvette mentioned that we did get some questions about marijuana. So let me throw the first question to you. Which states with legal marijuana laws currently prohibit or restrict pre-employment testing? I referred to that earlier, but which states are we actually talking about?
Right, so we talked about New York City. Now that's not the entire state of New York, but that's a city ordinance for any employees within the city of New York. The state of Nevada does as well. Nevada, it doesn't prohibit pre-employment testing for THC, but it prohibits what we call adverse employment action. So if you had someone test positive for THC in a pre-employment test, it couldn't be a reason you chose not to hire that person. Maine does not prohibit it, but in the state of Maine, if you're going to conduct a pre-employment test for THC or marijuana, it has to be done post-offer, which means you have to interview the person, offer them the job conditional on them passing the test before you conduct the test. So you can conduct the test, you can't just do it of all applicants though. It can only be after you've offered someone the position.
Okay, and so that kind of addresses the second question that was submitted about which states with legal marijuana laws require employers to prove an employee was impaired. And that's an interesting question from a legal standpoint, Yvette, I would assume, because there's no real legal precedent to say that if you test positive for THC that you're actually legally impaired. We don't seem to have that standard. Anything to add to that?
Yeah, well, the second question, I don't know if they're referring to pre-employment testing or testing of employees as well, because there are quite a few states that do have restrictions on what you can do when you have an employee who tests positive for THC. Most of those states, it has to do with medical marijuana users. So you would still be testing people for THC, for marijuana, because you're going to have plenty of people who test positive who are not using medical marijuana legally, do not have a card or whatever the requirements are for that state to use marijuana medically. But let me give you some states that do restrict. You know, what it would be is if you have an employee test positive for THC and they have proof that they are legally using it medically, you could not do any adverse employment action, meaning you couldn't terminate them, move them out of their position, or that sort of thing, unless you had proof that they were either using marijuana at work or they were impaired at work. And like you said, that right now with the science of marijuana testing, it's difficult to prove that only based on the drug test. You usually have to have some other kind of evidence that they were impaired at work, signs of impairment, a decrease in their productivity or their performance at work. Some of those states with those restrictions are Minnesota, Michigan, Arizona, New Jersey, New Mexico. Connecticut has a restriction like that. Connecticut's is based on the case law, which means an individual sued their employer and a judge decided and gave a written opinion saying, you know what, within this state, you can't fire someone who's using marijuana medically because they tested positive for marijuana. Again, that comes back to there's a big interplay in different laws here. You're going to need to look at the state's marijuana law, their medical marijuana law, their recreational marijuana law, case law that comes down from judges. There's just a lot to look at. Maine's recreational marijuana law is very tricky. When Maine first passed its recreational marijuana law, they had in their law provision that Maine employers or, employers who have employees operating in Maine could not terminate employment based on a positive marijuana test, whether it was recreational or medical. Then Maine kind of walked that back. And it's a little unclear now in the state of Maine whether you can terminate someone's employment for a recreational marijuana positive or whether you can't. So we're keeping our eye on Maine. What we're kind of advising people right now in Maine is to only act on impairment, but it's not crystal clear in the law in Maine right now. But most states, it has to do only with medical marijuana. If someone tests positive for marijuana and they don't have a medical card or a medical authorization, you're free to act on that. I'm going to give the caveat of Maine because it's still unclear there. Now, okay. Was that as mud or it's in flux and it's not easy to answer.
Okay, so now there are 11 states with recreational marijuana laws, and I know we're running short on time here, but how would you advise a client to address the marijuana issue in their policy? Not specifically, but generally, should they have marijuana, like a marijuana section in their policy?
I think they should. I think employers should. I think it's important to address it head on because it's confusing to employees as well. If marijuana gets legalized in your state, whether it's medical or recreational, your employees are not going to be clear on whether they're permitted to use marijuana or not. I think it's very advisable to test for marijuana because the use of marijuana has just skyrocketed and impairment marijuana has skyrocketed. When you have an impaired employee in your workplace, that's a liability in and of itself. Sometimes employers are only thinking about being sued by an employee as their liability risk. But if you have employees who are impaired by marijuana in the workplace, that's a danger, that's a safety danger. And so as a lawyer, I think that the right approach is to continue to test for marijuana. Like I said, almost every single state, recreational marijuana positive, you're going to be free to terminate employment to act on that positive. And for the few number of medical positives that you get, you're going to have information to act on you need to be watching for impairment in the workplace. You need to be watching for declines in work performance and productivity, because it's an issue that's not going away. And my thought is marijuana use is only going to continue to increase. So what are your thoughts about it though, Bill?
Yeah, I agree with that. And I would recommend additionally that, and we recommend this to all of our reseller partners, that companies should review their policy at least once a year, for sure every year, and update the policy to reflect, you know, the changes in any laws that apply to them. But say, for example, a marijuana law gets passed during the year and it goes into effect in May, like the New York City law did, you know, you're going to want to update your policy when the law becomes official, if not prior to that. So in other words, waiting a year till the end of the year to review the policy sometimes isn't the most prudent thing to do. And then, you know, you want to make sure that not only does it reflect the legal status of, say, marijuana in the jurisdictions where you work, but that you've also updated all of your employees and your supervisors on what's expected of them, how this law affects our workplace, our safety program, our drug testing program, etc., because everybody's going to be affected by it. And so we recommend that policies get reviewed and updated at least annually, but keeping in mind that perhaps during the year, you may have to update your policy as well. And also, for those of you who are using Current Compliance, which is our online state drug testing law database, if you're a subscriber or you have clients who are subscribing, a lot of these laws, well, all of the laws that Yvette's been talking about are found in the database. But if you do the marijuana laws, you're looking at Illinois, for example, at the top you have the option to click on marijuana and it will just show you the status of legalized marijuana in that state, but you got to scan down to the bottom of the page to find the marijuana information. But then it's there, it'll give you the status, and it'll also typically provide a link that you can click on that will take you to the actual statute where you can read the statutory language as well. Unfortunately, we're out of time. We just want to honor the fact that we said this would be a 30-minute webinar, and we have had some questions submitted. If there's any question, but many of them overlap with what Yvette's already been talking about. But if there, we'll go through all the questions. If there are any that we missed, we'll respond in an email to you. Also, everyone on today's call will have access to the recording of this webinar. And after the webinar, after we close today, please feel free to submit any additional questions that you have. It's all part of the reseller agreement that we have with you. So if there's any other questions that you have, submit them. We'll look it up and then we'll get an answer to you. Any closing remarks, Yvette?
No, just thank you. No, okay. Thanks.
Perfect. Now, I just have to tell our audience that Yvette is in Hawaii, and so she had to get up very, very early this morning and to prepare for this. So we appreciate that very much, 6-hour time difference. Thank you to everybody who has been on today's webinar presentation. For just the closing instructions, I'll turn it back over to Jessica. Thank you again.
Thank you so much, Bill, and thank you, Yvette, for your time and your expertise. On behalf of the Current Consulting Group, we'd like to thank all of those of you who participated in today's webinar session. And with that, we conclude today's webinar presentation. Thank you and have a great day.